Please be seated.
The court is now in session. Mr. Dukpari is now directed to report to the Chamber on the current status of the parties to the proceedings today. Dukpari, good morning, Mr. President and Your Honors. Parties to the proceedings today are all present. Mr. Nunchi is present in his holding cell downstairs, as ruled by the trial chamber due to his health concerns. During today's sessions, we have a reserve witness, TCE 33. This witness is available to be called in the afternoon. This witness already confirmed that, to the best of his knowledge, the witness is not in a relationship with an accused or a civil party. The witness will take the oath before the chamber when the witness appears before the chamber. Thank you, Mr. President. The President, thank you, Mr. Dukpari. Next, the chamber would like to now hand over to counsels for Mr. Nunchi to continue making observations regarding their responses to the presentation of the key documents presented by the co-prosecutors and the lead co-lawyers for the civil parties on the 24th to 27th of June. You may now proceed. Counsel Son Arun. Good morning, Mr. President and Your Honors. I would like to continue from what we left off yesterday late afternoon regarding our responses to the key documents presented by the co-prosecutors. Today, I am discussing about S21. Your Honors, I would like to turn now to S21. I would like to first repeat the objections made by my colleague, Mr. Kope, yesterday morning. It makes no sense that we were talking in this document presentation hearing about Nunchi's role at S21, which is outside the scope of this trial. This chamber has twice refused the prosecution's request to include S21 within the scope of this trial. Nunchi's role at S21 is not about his role in relation to an alleged CPK policy. It is about his role at a crime site. There is not enough evidence before this court to make any findings on this subject. There are several topics on which this chamber would need to hear live testimony in order to make findings about Nunchi's role at S21. Those topics include, for example, The President, Counsel, can you please hold on? And Mr. Co-Prosecutor, you may now proceed.
Thank you, Mr. President. Good morning to everybody. The Council is again straying from the purpose of this hearing, which is to respond to the documents that have been presented. He's now making an argument relating to whether or not S-21 is part of the case, whether additional testimony would be required about S-21. He's not responding to the documents. I would refer him also to closing order paragraphs 877, 878, and 879, which are part of this case. All three paragraphs directly concern one subject, Noon Chea's responsibility for S-21. Nevertheless, the purpose of these hearings is not to argue about the scope of trial. The purpose of these hearings is for the defense to respond to the documents we presented.
Counsel Sonarun, Mr. President, please allow me to respond to the comment made by the co-prosecutor. This is just part of the introduction before I proceed to our response to the co-prosecutor's submissions, because first we should begin with the introduction before we come to the body and the conclusion. With that, may I ask for your leave to proceed, please? The President. Counsel Sonarun, please be informed that the Chamber has already informed the parties to the proceeding regarding the topic for the hearing, and the Chamber has just indicated that counsels from Mr. Noon Chea would proceed to make observation regarding their responses to the key documents presented by the parties to the proceedings, including the co-prosecutors and the lead co-lawyers for the civil parties. Documents presented during the hearings on the 24th to the 27th of June 2013. It was a week ago, so the message is clear. Could you please now be directed to frame your observation to be in line with the agenda the Chamber has already notified the parties, and please refrain from making things that are not relevant to this part. Otherwise, you are straying away from the main agenda of today's hearing. Counsel Sonarun, I am rather stunned by this because co-prosecutors would also need to go through some introduction before they could proceed to the body. The President, indeed it is on your side. You appear to be irrelevant regarding this. Yesterday you were already been reminded regarding the general scheme of your observation, and you mentioned about some 5 key documents. Then you dwelt on other general aspects before you went through these 5 documents. People understood your position differently. So to make sure that we are not misled, then please proceed to only the relevant part of the observation regarding the responses to the prosecution and civil party lawyers. Counsel Sonarun, thank you, Mr. President. I would like to now proceed to the actual responses. The co-prosecutor's evidence about Nguyen Chia's role at S-21 was almost entirely about S-21 confessions. The prosecution described 26 confessions with annotations which allegedly show those confessions were sent to Nguyen Chia. Then they showed you 6 confessions with annotations which they claim were made by Nguyen Chia. The prosecution says that these documents show that Nguyen Chia had a role at S-21. Your Honors, we submit that the documentary evidence presented by the co-prosecutors does not support that claim in any way. In fact, we would submit that if the evidence shows anything, it shows that Nguyen Chia had no role at S-21 at all. In order to prove that, I will first discuss the 6 confessions which the co-prosecutors claim contain annotations made by Nguyen Chia. I will then discuss the confessions which were allegedly forwarded to Nguyen Chia. I would like to begin examining the prosecution's claim that Nguyen Chia annotated 6 S-21 confessions by examining one of those confessions in detail. That confession is from a cadre named San Yip. The document number is E3/175. According to the prosecution, Dutch has testified that one small annotation on the site was made by Nguyen Chia. Is that true? To answer that question, I would like to show the chamber a document. The document number is E3/359. It contains Dutch's answer to certain written questions. This is a document in which the prosecution claims Dutch identifies the annotation on San Yip's confession as belonging to Nguyen Chia. I would refer the chamber to ERN English 00434339, Khmer ERN 00408224. At the bottom of that page, at point 11, Dutch writes the following about that confession. Document D43/4 in case file 002. I have just received document D43/4 in case file 002, and it is the sole Zone 801 special branch document that I have ever seen. So Dutch has not, in fact, testified that Nguyen Chia made this annotation. He has not testified to that fact because he had never seen the document before the day the investigating judges showed it to him. Rather, Dutch is only able to tell this chamber whether the annotation on this document looks like Nguyen Chia's handwriting. Now, as the chamber knows, Dutch is not an expert in handwriting. He is not able to give this court his opinion about whether two different handwriting samples look alike. He is only able to tell the chamber whether he specifically remembers and can personally identify Mr. Nuon Chia's handwriting. Your Honors, in interpreting the prosecution's claim that Dutch personally remembers what Nuon Chia's handwriting looks like, we would like to invite you to exercise some common sense. Dutch claims he last saw Nuon Chia in 1979. Dutch was interviewed by the investigating judges for the first time in 2007. Almost 30 years passed in between. We would ask Your Honors to put yourselves in Dutch's position. We would like to invite the members of the public gallery to do the same. Would you remember what your boss' handwriting looked like 30 years after you last saw him? As this chamber knows well, Dutch is an intelligent and well-informed witness. He studied the case 001 case file extensively. He followed the developments surrounding this tribunal very carefully. Your Honors may be aware that earlier this year, former investigating Judge Marcel Lemonde wrote a book about his experience at this tribunal. Even Judge Lemonde recalls that it was often difficult to figure out whether Dutch was testifying from memory. The President, could you please hold on, Counsel? Mr. Co-Prosecutor, you may now proceed.
Thank you, Mr. President. I would object to Counsel's presentation of this document, which was rejected by the trial chamber, and it's entirely inappropriate for Counsel to be standing here making representations about what Judge Lemonde's views were in any event. So this is not a document that has been admitted and not a document that can be presented to Your Honors.
Counsel Son Arun. Mr. President, would you wish me to skip to another paragraph, or would you wish me to respond to the co-prosecutor's comments? The President, it is your sole right to respond to the co-prosecutor's remarks, because the chamber would wait for this moment before we finally rule upon this objection. If you would like to skip to the next paragraph, then you can do that on your own volition. And again, this document, as indicated, has never been presented before the chamber by any parties of the proceedings, including the co-prosecutors, the lead co-lawyers for the civil parties during the entire time in the courtroom in document hearing, in particular on the 24th to 27th of June 2007, rather 2013. Counsel Son Arun. With that, Mr. President, I may skip the part on Judge Marcel Lemonde, and I would proceed to another paragraph. Mr. President and Your Honors, again, we ask you to exercise some common sense. Is it more likely that Dutch actually remembers what Nuon Chia's handwriting looks like 30 years after the last time he saw it? Or is it more likely that he inferred that the markings on the confessions belonged to Nuon Chia because he was told so many times about Nuon Chia's role in the intervening years? Your Honors, we think the answer to this question is obvious. We think it is extremely unlikely that Dutch has an independent recollection of Nuon Chia's handwriting. However, the Chamber need not rely on our opinion. It need not even exercise its own common sense. Dutch himself has told this tribunal that he cannot recognize Nuon Chia's handwriting. And to show that, I would like to display document number E3/355. This document is a written record of interview of Dutch in case 002. It was taken the day before Dutch answered the questions which we saw just a moment ago. In that interview, Dutch talks about the same confession belonging to San Iep at ERN in Khmer 00239834 and English ERN 00242876. Dutch notes the annotation which the prosecution says is written by Nuon Chia. He says the following: I don't know who wrote that, but it was not Pol Pot, whose handwriting was similar to mine. Like Sun Sen's and Von Wait. Perhaps Nuon Chia wrote it, but that is just my assumption, because I did not see this handwriting often. Your Honors, this is a statement of the man whose evidence is the only basis this tribunal has ever been given to conclude that Nuon Chia annotated any S21 confessions. We would ask the Chamber to take note of the fact that Dutch has specific recollections of the handwriting of Pol Pot, Von Wait, and Son Sen. Yet he is unable to make any independent determinations about Nuon Chia's handwriting. It would seem, then, not only that Dutch was not accustomed to receiving written instructions from Nuon Chia. It would also seem that he interacted more often with other senior members of the Khmer Rouge regime. In other documents in which the prosecution says Dutch identifies annotations as belonging to Nuon Chia, it is equally clear that he has no real basis on which to make that conclusion. For example, in document E3/1547, another written record of interview, Dutch discusses the confession of Mie Tuj alias Cam. My apologies, Mr. President and Your Honor. I would like to read this number of document again. This document is E3/1547, which is another written record of interview which discusses the confession of Mia Tuj alias Cam. That was another one of the confessions presented by the prosecution last week. At ERN Khmer 00174100 and English ERN 00771346. Dutch claims to know that Nuon Chea made the annotation, Comrade 1, quote unquote, on the side of the confession. How does he say that he knows that? The only way he says he knows that is, he claims, that if Son Sen had addressed Ieng Sari, he would have written, in quote, Brother Van, end of quote, instead of, quote, Comrade 1, end of quote. But only seconds later, on the same page of the interview up on the screen, he admitted, and I quote, I do not know the details of how the superiors worked together. As we have seen, he also concedes that he rarely saw Nuon Chea's writing. The obvious truth is that he has no idea how either Nuon Chea or Son Sen spoke to Ieng Sari. In the three other documents in which the prosecution claims Dutch identifies annotations as belonging to Nuon Chea, Dutch provides no explanations at all for his conclusion. And for the benefit of the chamber, those are document number E3/1546, Khmer ERN 0, rather English ERN 00173049, and this document is in relation to the confession of Mok Samol alias Hong, document E3/1548, in Khmer, ERN 00174132, and English 00767463, in relation to the confession of San Po, and E3/1098, Khmer ERN 00406602, and English 00524161. The President. Mr. Arun, you haven't given the EN number in French because, look, parties to the proceedings would include French nationals as well, so you should also refer to the French EN number if you can.
Please turn on your mic. Counsel. My apology, Mr. President. I do not have the French ERN with me at the moment. I only have English and Khmer ERN. The President. You may now resume. The President. Judge Zongmak Lavange, you may proceed.
Council Sanahunu, I understand that today you did not have the time, of course, to prepare your hearing properly. This is why you were not able to find the French ERN numbers. But could we hope maybe that sooner or later you will provide this information to the Chamber? Thank you.
Council Sonoran, my apology, Your Honors. I am going to provide this relevant ERN's number at a later stage.
Can we say, Council Sanahun, that you will be able to give us this information within 2 days? Within 2 days, would that be possible?
Ban.
Yes, of course, Your Honor. May I continue, Mr. President? Only one thing is clear in those documents. Deutsch has no specific recollection of any of those confessions or any actual knowledge at all about any of those annotations. Your Honors, obviously this is an important allegation. Mr. Nguyen Chia has always consistently denied it. The evidence supporting the allegation comes from only one witness. And for the reason we have already stated, that witness testimony is not reliable. Under these circumstances, the Chamber should, at a minimum, engage a handwriting expert before concluding that the annotations belong to Nguyen Chia. If it does not choose to take that avenue which is available to it, it would be unable to conclude beyond a reasonable doubt that the handwriting belongs to Nguyen Chia. Your Honors, that concludes our discussion of the confession which the prosecution alleges contain annotations written by Nguyen Chia. And I will now discuss the rest of the confessions, the ones which the prosecution says were sent to Nguyen Chia. I would like to begin by quoting something the prosecutors recently said. The co-prosecutors recently filed a submission with the Supreme Court chamber about the severance of the closing order. It was a response to an appeal we lodged against this chamber's second decision to sever the closing order. That was document number E284/4/3. ERN Khmer 00921840 and English 00921816. In that response, at paragraph 21, the co-prosecutors tried to show that Nguyen Chia had a role at S21. And in doing that, they talk about the confession. I'll quote a sentence from their submission, which is at paragraph 21. Quote, the co-investigating judges found at least 27 confessions with annotations indicating that a copy was sent to Nguyen Chia and another 6 S21 confessions bearing Nguyen Chia's handwriting, end quote. Mr. President, here is what we find interesting about this quote. The co-prosecutors try to convince the chambers of this tribunal that because Nguyen Chia supposedly saw 33 confessions, that he must have had a role at S21. So our question is this. What is the 33 confessions? Is 33 a lot? 33 of how many confessions? How many confessions are on the case file? We also concur with the prosecutor that these may have some relation with military structure, and this confession was sent to Nguyen Chia. And the mere fact that these documents were sent to Nguyen Chia, it was not because he had any role in S21, but this document was to be sent from the military authority, and Mr. Nguyen Chia might have already forgotten this information.
នេះដោយលើកឡើងថា
And this document has been sent to Nguyen Chia, and the prosecutor claims that Mr. Nguyen Chia had a role in military structure, and he was involved in the purchase of the military personnel. This was the quote that the prosecutor brought up on the 27th of June. Your Honor, to be clear, Mr. Nguyen Chia did not concur with the allegation that he had a role in purchase of military personnel in the central zone. But I would like to draw attention of the chamber that even the prosecutor themselves failed to explain consistently the reason for the submission of these statements to Nguyen Chia. But this statement sent only from S21, or it was sent for other purposes. The document failed to enlighten the chamber on this, and I believe that the prosecutor themselves did not know. And for this reason, the chamber does not have any basis for the decision.
ខ្ញុំអស់មានអត្ថាធិប្បាយ
Mr. President and Your Honors, I do not have any additional observation, and I would like to request to Mr. President and the Chamber that my client would like to make an observation on the various key documents presented by the prosecutor, and we are seeking permission from the bench, the President. Yes, he may proceed. The President, Mr. Nguyen Chia, the Chamber grants you the opportunity to respond to the various key documents that have been put before the Chamber by the co-prosecutors and lead co-lawyers for the civil parties. You may proceed, Mr. Nguyen Chia.
Mr. Nguyen Chia, I thank you very much indeed, Mr. President.
thân gia
The President, every booth, can you advise the chamber as to what problem we are facing technically? It is important that we are informed so that we can proceed or decide how to proceed. Mr. Nunchia. Mr. President and Your Honors, I am Nunchia. I would like to make some statement in response to the key documents presented by the co-prosecutors on the 24th through the 27th of June 2013. Your Honors, during the past few days, commencing from the 24th to the 27th of June, from my holding cell downstairs, I attentively paid attention to the presentation of several documents by both the national and international co-prosecutors. Though I sometimes got what the prosecution submitted, there were times that I could not follow what being discussed due to my poor health conditions. Nonetheless, I understood enough to believe that what were raised by the prosecution appeared to be neither accurate nor corresponding to the actual events that had happened during that period. I would therefore like to crave your honor's indulgence, for I wish to enlighten the court on these matters. With that, I would like to contest the entirety of the content and the form of documents presented by the prosecution as follows. First of all, I'd like to address the issue of A. Evacuation of the people. A few years ago, I already testified that after the Liberation Day of the 17th of April 1975, all city dwellers were evacuated, and it is obvious. In any event, the evacuation was not forced. The leadership had to make such decision based on two main reasons. First, it was fear that Americans would drop bombs on cities after London's government was defunct. This made the leadership believe that the aerial bombardments would be carried out again onto the cities, especially the city of Phnom Penh. Your Honors, it is well known that the Americans supported Lon Nol's regime and South Vietnam, while North Vietnam was in support of the democratic Cambodia against South Vietnam and the Americans. As a consequence, the Americans believed that North Vietnam and the democratic Cambodia were its enemies. For a period of 300 nights and days, the Americans had dropped several million tons of bombs onto Cambodia. The destruction caused by the bombings was of mind-boggling scale, when properties, homes, pagodas, cattle were hit, and several thousand of innocent lives were killed. Noting this unfortunate tragedy, which would most likely happen again, and to ensure safety and security for the people, the leadership of the democratic Cambodia, Pol Pot in particular, decided to evacuate people from the cities. Second of all, Cambodia had gone through war for over 5 years already. This made the country face several challenges, including food shortages. Food shortages were the primary concern to be addressed very urgently. At that time, Cambodia did not receive any aid or assistance from foreign countries. In the light of these dire circumstances, people were required to take part in rice production by themselves to support their livelihood and to build the country. In spite of the above-mentioned reasons, the evacuation of the people at that time was done on a voluntary basis, without any coercive measures, violence, or killing of the people. To maintain this principle, people were educated and well explained about the danger of the Americans' aerial bombardments on cities and the need to resolve food shortages for the livelihood of the people and for building the country ourselves. At that time, people appreciated the danger the country faced and its need. In particular, people supported and loved the revolution. Eventually, people gradually had left the cities after they had received our appeal and explanation to do so. Your Honors, I would wish to bring to your attention some documents that are improper and that cannot be used as the basis for the Chamber's consideration in its ruling to find justice for me and the victims. These documents include, first, the revolutionary flags. The co-prosecutors submitted based on some information regarding the revolutionary flags as the inculpatory evidence against me. Factually, the revolutionary flags had nothing to do with me. The reason I say so because the revolutionary flags were the medical messages, rather the political messages by the senior leaders of the regime. These magazines were not legal documents that had to be applied. Before the victory on the 17th of April 1975, as well as the aftermath of that liberation, that message, the political message in the magazines, were very important to gather the forces of the democratic Cambodia. Because Cambodia, during that period of time, indeed after the internal war was over, there were wars in which a neighboring country, including Vietnam, invaded Cambodia. Vietnam never wanted Cambodia to be in peace. They used or employed all dirty tricks and tactics to topple Cambodia. For that reason, Pol Pot had to release political messages in the magazines to show the people that the leadership was still strong, firm, and that most of the time the information is not accurate. If we look carefully into the content of the revolutionary flag magazines, we can note that the majority of the articles published in these newspapers or magazines were mainly the statements by Pol Pot and the report collected from each sector or zone across the country. This has already been confirmed in the references the co-prosecutors refer to in the hearings from the 24th to the 27th of June 2013. As a principle, the revolutionary flag magazines were examined by the standing the Central Committee. Nonetheless, it was Pol Pot alone who made all the decisions before any articles could be published. So, all in all, the decision was made not by collective but by Pol Pot. He himself had his own personal assistant who was fully in charge of writing the articles and publication of these magazines. I still remember that there is another person by the name of Kum Wun, alias Chaum, who worked in this group. At that time, even though the members of the Central Committee didn't see the right thing being said, no one would dare to challenge such a decision. Pol Pot had all the power, absolute power. Whatever he said, he meant business. In the socialist regime, the people who had all the most power had the decision on the fate of the country, and it was only one person who was behind all the decisions. It was the secretary of the party. Your Honors, I am interested in the accuracy of the documents being put by the co-prosecutor regarding these documents, including the revolutionary flags. And the main point that I wish to draw your attention to is the original documents that the prosecutor put before the chamber. On this point, I already made my submission time and again from the very beginning that documents of original source had to be placed before the chamber or showed to me, but all to no avail. I don't understand much about the rule of evidence, but I fully understand what justice is. So far, the co-prosecutors presented some documents which were mainly inculpatory documents, and they were the copied versions. I believe it is not fair for me to be presented such copied documents, because after all, no one knows whether these documents are genuine or they were the fake ones. On top of that, if the chamber allows such documents to be examined, there were chances that the document could be fabricated or changed easily, and justice will be compromised, and the truth will never be found. So, I would like to absolutely take issue with all the documents presented by the co-prosecutors against me. Secondly, the citation of documents from books. According to or in these proceedings, I have also noted that several articles from books were quoted by the co-prosecutors against me. These books include the books from Mr. Philip Short, Mr. David Chandler, Mr. Poncho Francois, and Mr. Ben Cannon, etc. When it comes to this point, I feel I am stunned, and I don't understand why the co-prosecutors resort to using such documents as the core documents against me. Factually, these books, although there are pieces of document inside, they are not 100% true. The quality of truth in that is questionable. In general, in order to make sure the book can convince the readers, the authors had to apply some of their methodology and techniques in making sure that people want to read their books. With that, the truth is compromised. And I believe that these hearings before us is not part of a theater. It's not a play. So we need to have all the reasons, genuine reasons, to be examined and to be used for the consideration of the final decision in the case. Above all else, if we look more deeply into this aspect, the information gathered by all the authors in their books, these pieces of information were collected from interviews with individuals the authors believed could provide important information to them. To that effect, who can assure or can guarantee that whatever that individual says in the interview is true? Authors and the reporters are not different. They cannot claim whether the information they obtain through interviews is 100% true. They can only say that they have obtained these pieces of information from A or from B. That's all. Other than that, they would not be able to comment further. And if we would like to know more about this, we have to really meet those individuals personally to obtain further information or to verify the content of the information. Nonetheless, there are still some shortages. So it is really important that witnesses that appear before the chamber had to take the oath before he or she is examined. Otherwise, the information from them would not bear any property value before the chamber and after all cannot be used. Also, authors of the books are foreigners. They don't speak Khmer. So the information they obtained is gathered through the interpreters. Therefore, it lacks integrity and truth. In conclusion, the information obtained from interviews is nothing short of the hearsay pieces of information or evidence. And as it says in Khmer, there is a folk tale about from 1 crow to 10 crows. And this is the same when you hear a piece of information from one person, this information can be exaggerated to 10 times bigger than the original information. And the Khmer folktale is meant to educate people not to believe in hearsay pieces of evidence. And it has been here in Cambodian society for all along. And if the chamber were to rely heavily on the hearsay pieces of evidence, I'm convinced that this court would not be able to find proper justice for every one of us. I therefore would like to reject and would like the chamber to reject all the evidence that is quoted from those books as I cited. Third, minutes of the meetings and the documents that I was forwarded. Regarding this, the co-prosecutors also refer to these documents against me, and the references mainly refer to my presence in meetings or the document sometimes entitled Copy to Uncle Chia or Nuon Chia. On this, I wish to also make observation that I do not remember how many times I attended a meeting where Pol Pot attended during the time when I had worked with him. I feel, however, that some information is not true or is still questionable. Nonetheless, even though I attended any of the meetings, that doesn't mean that I engaged in decision making. There were several meetings that other people attended, but it was not necessary that they had to make any decision. And most of the time, attendees did not challenge a decision made in the meeting. With that, the co-prosecutors cannot conclude that because I was present in the meeting, I also engaged in decision-making. Likewise, there were other documents entitled in which I was copied. That means I did not attend such meetings or engage in any of the decision-making. Although I was copied, sometimes I did not receive such documents. Although I may know about them, I had no authority to do anything about this. I had no authority to stop people from implementing the decision. I therefore would like to contest any attempt to bring these pieces of evidence against me. B. The supervisory role and my role. Once again, I would like to make it clear that during the Democratic Cambodia, I was holding 3 roles in particular. First, Deputy Secretary of the Democratic Cambodia. In this position, I was tasked with the roles of propagating and educate people about the policy among the members of the party. At that time, there were not many member parties. With regard to the content of the education session, I never educated members of the party to be bad people or to be misconduct, to behave improperly, for example. I educated only to people to love the nation and country and others. I never educated any member of the party to kill, mistreat, starve, or to commit an act of genocide. Even once, I never did that. Factually, I already mentioned that in the sessions, I educated people on how to strengthen security and safety against the enemy. I think it is not uncommon because the leadership at all countries in the world would have to bear this responsibility to ensure that the country is well protected and security is well preserved for its own people. For example, recently, America has announced that it is hunting Edward Snowden, and they would like to send this person for prosecution as he is accused of violating the security matters of America. Second, the deputy chairman of the committee to negotiate with the Labour Party of Vietnam. In this role, I did my best to coordinate, negotiate with Vietnam to to strengthen our relationship and peace with this neighboring country. But it was not successful because Vietnam really would like to wage war and invade Cambodia. 3. I was the president of the People Representative Assembly of Cambodia. As you know, that during the democratic Cambodia, like in the other communist country, the party leads the country, but the state was in full control of the state. And at that time, the institutions or the management of the state was seen in clear division of power. First, the executive body, legislative body, and the judiciary. Pol Pot was in charge of the executive body, when I myself was in charge of the president of the People's Representative Assembly. And in this role, I was in charge of making sure that the laws was passed. And also, since Cambodia has just recovered from war-torn phenomenon, with Vietnam in particular, we did not have enough time to adopt any new laws. Regarding another role, I did never perform that role. I would like to take issue with the assertion that I used to be the acting prime minister rather, or the person in charge of military committee, or I was involved with the supervision of S-21 because I was implicated. Please be informed that Pol Pot was the deputy prime minister. Rather, Pol Pot had his deputy prime minister, who was Mr. Ieng Sari, Son Sen, and Von Wait. So, there was no reason that Pol Pot would like to appoint me as the acting prime minister apart from the deputy prime minister that I just mentioned. And it is true that he would not do that when he was absent. I would like to also solemnly declare that I engaged in the democratic Cambodia for the purpose of liberating Cambodia and protect Cambodia from being invaded by the neighboring country. We know that this neighboring country would like to swallow Cambodia all along. I love my own people, and I have no reason to mistreat or commit any crime of genocide against my own people. Finally, I would like the court to kindly consider my request regarding my rejection of all the documents presented by the co-prosecutors, and it is really important for the purpose of the truth and justice for me. Thank you very much, Mr. President and Your Honors.
The President. Thank you, Mr. Nguyen Chia. Before the morning break, I would like to ask the prosecutor. Yesterday, the chamber received an immediate request filed by the prosecutor to respond to document E288/4 filed by the defense team for Mr. Kieu Sampon, dated on the 5th of July 2013. The chamber would like to know the position of the prosecutor, whether or not you are ready to respond to this document. If so, you may proceed.
Thank you, Mr. President. Good morning, Your Honours. Good morning, Council. and everyone else in the courtroom, thank you for this opportunity to make brief submissions on the filing that we all received yesterday. And let me say at the outset that we are all, certainly on this side of the courtroom, stunned by this latest and very belated change of position by the Khieu Samphan team and, of course, by the accused himself. If you permit me, I will, for context, briefly outline 5 requests which the Khieu Samphan team says have been rejected and which have apparently or supposedly resulted in the decision which we've been informed of. Firstly, and this is all in E288/4 at paragraph 7. Firstly, we are informed that the first primary reason for Khieu Samphan's decision not to testify is that the chamber has refused to give him a list of questions by topic to which he would be required to respond in court. Secondly, he says that the chamber has failed to order the provision of a list of documents which would be used in that examination, such list to be limited to what Khieu Samphan considers reasonable. Thirdly, that they have been denied a request to have 3 weeks for preparation prior to the commencement of examinations. Fourthly, that issues in relation to counsel's access to the detention unit on weekends have not been adequately resolved. And finally, even though this clearly was not refused, a request to have to give testimony only half day for each day of court sitting. So those are the 5 grounds as we understand them. Of course, there are other procedural complaints raised. We take issue with all of them. We find them wholly unconvincing and misleading in numerous respects, and we will file a formal written response. But those are the 5 key procedural concerns that apparently have led to this last-minute change of heart. Now, it is important, I think, given the significance of this decision, that we review briefly the procedural history of this matter. It's important to say, here in open court, with the accused present, with the victims watching, and with the Cambodian people watching this proceeding, that Khieu Samphan has stated consistently, from well before the start of this trial, that he will testify. He said that on the 13th of December 2011, when he was instructed by Your Honours to state his position. He said it earlier, in fact, also on the 23rd of November 2011, in unequivocal terms, that he will respond once he hears the evidence. That also was a position echoed by his counsel. That position remained unchanged, and in fact, Khieu Samphan has made statements, thereby giving evidence during the proceedings, and he has also, more recently, commencing on the 27th of May 2013, specifically answered questions from civil parties, thereby again giving evidence before Your Honours. Before I continue with the procedural history, I'll pause here to observe that the legal implications of Khieu Samphan's position, his statement, and his giving of evidence are that he has unilaterally and unequivocally waived his right to remain silent in this trial. He has not exercised his right to remain silent. He has, in fact, elected to give evidence and has given evidence. And that has implications for his decision now to stop testifying. And we will come to that in a few moments. Now, turning to some of the conditions that have been raised by the defence, the discussion of these conditions commenced on the 27th of May 2013. Your Honours will recall that you had instructed the accused to state their position in relation to testifying in the final stages of the trial, and you in fact gave them a weekend, a period of 3 or 4 days, to consult their counsel. And then on the 27th of May, in court, Khieu Samphan confirmed that he will be testifying, that he will be answering questions. He did at that point, and this is at time marker 90801, say that he would like to know the content of the questions he will be asked. Mr. President then informed him that that would be unlikely, that an accommodation of that request would be unlikely because you can't write questions that will be asked as you would do on a blackboard in a school, that is impossible in an adversarial process. And of course, we would add, certainly departs from any international or domestic practice known to any legal system that we're aware of. Following that exchange, at 9:12:15, Mr. Verken clarified the issue and said that Mr. Khieu Samphan was not in fact asking for a list of questions, but instead, and I quote him, all they want is general topics that will be brought up, as well as a list of documents. That was the position on the 27th of May. And let me say here that whilst a request for a list of documents and a request for topics exceed accepted international standards, we take no issue with them, and we will come back to that point when we invite Mr. Khieu Samphan to once more reconsider, perhaps for the final time, his position. These additional requests for lists of questions emerged only on the 11th of June 2013 in preparation for the trial management meeting, and this is in document E288/2, where a list of questions was raised for the first time. It's interesting that at the trial management meeting itself, on the 13th of June 2013, that issue was not again raised by the defence. There was no request for additional documents to be provided at that point. The requests at that point were for a break of 3 weeks in proceedings to enable the accused to prepare. And of course, the request had previously been made for a list of documents and a list of topics. In relation to the complaint which is also made in this latest pleading as to unlimited time for questioning, Your Honours will recall that you had invited the parties to provide indication as to how much time they required. We estimated approximately 6 court days for the examination of Khieu Samphan, and we asked for some flexibility. Your Honours, in our opinion, quite wisely, elected not to place time limits, but instead decided to obviously allow the proceedings or the examinations to continue for as long as they remain pertinent and for as long as questions were relevant, and for as long as the accused were able and willing to participate. And that, in our view, is an entirely reasonable position at this stage of the proceedings. Coming back to the specific requests that have been made, I want to state clearly on behalf of the Office of the Co-Prosecutors that even though these requests exceed what is accepted international practice, even though they exceed the accused's actual rights, we want to make sure that every reasonable opportunity is given to him to answer questions, as he has been promising now for almost 2 years. From our side, we are prepared to give him a list of documents, which is something Your Honours have already accommodated. We're also prepared to give them a list of topics that will be discussed in the examination, on the understanding that obviously the list of documents or the list of topics cannot be entirely exhaustive. It can only ever be indicative because, as Mr. President has indicated, examinations are adversarial, issues can be raised by the accused, and it is impossible to provide an exhaustive list of every subtopic that may come up. But certainly we are prepared to give him a relatively detailed list that would give him a clear indication as to what topics would be discussed. That, of course, is in addition to the list of topics that is available in the closing order, which could not be clearer as to the issues that the Chamber is concerned in this trial. But we are prepared to provide that, and we will provide it within 24 hours, provided if the accused now agrees to answer questions. As for the extra time to prepare, we're in agreement with Your Honours that having had access to this file for 5 years and having participated in the trial for 1.5 years, the accused is well on notice of the issues that he will be asked about. There is really no need for extra time. But again, if Your Honours consider that that accommodation should be made, if you consider that that is something that should be attempted, then we will obviously not object. We want to make sure that he is given every conceivable opportunity and a reasonable opportunity to prepare and to answer questions, as he has promised from the beginning. And here I come to the legal implications of a decision to refuse to answer questions. We, in fact, feared as early as February 2012 that we may reach this juncture. And we filed a request, which is document E174 of the 17th of February 2012, in which we invited the Chamber to notify the accused as to the implications of a selective exercise of decisions as to whether or not to testify. The Chamber, having received that request, then did in fact inform all accused as to the implications of selective decisions on testimony. And Your Honours did that on the 18th of April 2012. The transcript is E1/63.1, and the specific instruction or direction is given at time marker 11/12/32. And there, Your Honours clearly state that the relevant international jurisprudence indicates that adverse inferences from selective decisions to remain silent may be drawn. That instruction is entirely consistent with international jurisprudence. Once an accused gives evidence, as Q Sampan has done in this trial, a refusal to answer questions can lead, and in our respectful submission, now must lead to adverse inferences being drawn on the evidence against him. And we want to state that now, because we have in fact reached a stage where this is not a hypothetical scenario, but in fact an apparently firm decision now by the accused to reverse his course. And I will refer Your Honours to only 2 or 3 authorities on this matter. The first authority comes from the International Criminal Court. It's a decision of the 13th of September 2011 in the case of Katanga. And the relevant paragraphs are paragraphs 7 and 8, where it is made clear that once an accused testifies or gives evidence, his or her decision to decline to answer further questions may lead to adverse inferences being drawn. Again, consistent with Your Honour's ruling. The second authority is Prosecutor and Blagojevic, an ICTY decision of the 30th of July 2004, where the trial chamber of the ICTY gave notice of rights to the accused, and you will find at paragraph 24 that this position is stated in relation to adverse inferences. More broadly, this principle applies in domestic legal systems and has been upheld also by the European Court of Human Rights, and you will find, Your Honours, in the decision of Murray and the United Kingdom, a decision of the 8th of February 1996, that the principle is upheld that a right to silence is not an absolute right, and that in certain circumstances an adverse inference can be drawn on the evidence against the accused. So our respectful application is in 2 parts, Your Honours. One is that Your Honours consider allowing these additional accommodations that we have now indicated as to lists of questions and as to lists of topics and lists of documents, as well as, if Your Honours consider it appropriate, a period of time, 2 or 3 weeks, as Your Honours find suitable for preparation, so that there can be no suggestion that any opportunity to prepare was denied, and that the accused now be requested to state once and for all clearly in court, with these accommodations having been made, whether or not he will answer questions. And the second part of our applications, Your Honours, is that if he then states that he will not testify, that Your Honours confirm your prior notice and in fact now specifically warn him that adverse inferences will be drawn against him on the evidence when you deliberate in your consideration of a judgment in this case. Those are our respectful submissions. We're at your disposal, of course, if there are any questions that you wish us to address. Thank you.
The President, thank you, Mr. Prosecutor, and Madam Lead Co-Lawyer for the civil party. You may proceed.
Yes, thank you, Mr. President. I would like simply to add a few words in the interest of the civil parties following the decision taken by Khieu Samphan and his defense team. It's obvious that we regret this decision, which was announced to us yesterday, and we regret it because after the hearing that took place at the end of May, at the beginning of June, with the civil parties, we were able to gauge the importance of the fact that Mr. Samphan had accepted to answer the questions put by the civil parties, so we're perfectly aware of the importance of such an act then. Now, Mr. Khieu Samphan is now presenting himself as a voiceless accused person obliged to remain silent. Of course, we accept this right to remain silent, but we'd like to remind you of Khieu Samphan's statements that were reminded by the prosecutor. Mr. Khieu Samphan always said that at the end of the proceedings he would speak and he would answer questions. And we believe, as the prosecutor, that in terms of preparation for these questions, Khieu Samphan should not be considered differently. This trial has been going on for 5 years with an investigation which allowed Mr. Khieu Samphan to prepare his defense and to prepare his responses and to prepare his explanations at the end of this trial. And we believe that the obstacles he's speaking about at the end of the requests are the same for everyone here: problems of staff, problems of numbers of documents, and this is what we all are facing here. Now, regarding the time for the questioning that the Khieu Samphan team understands as being very, very long, and I understood something like 4 weeks, well, I don't think that this is accurate. I understood that the Chamber's decision not to limit time was also something that would be in the interest of the accused. That is to say that the Chamber would allow the accused to take the time to rest if necessary and to remain silent if they felt it was necessary. So I do not believe that the fact that the Chamber has said that the fact that time is illimited is something that is contrary to, or that is against, that contradicts the rights of the accused. I also would like to stress that, as far as I'm concerned, answering questions does not mean only meeting the interests of the prosecution and of the civil parties, but it's also in the interest of the accused persons. And here I would like to support what the prosecutor said before. And beyond that even, I think it's the moment for someone who states to be innocent to come provide answers and explanations. And it is in his interest, and it is certainly, obviously, an important opportunity for him as well. And I will finish now, returning to what I said at the start of my submission. I thought that I had understood that Khieu Samphan wished to answer the civil parties originally, and therefore I am almost convinced now that he wishes still to answer questions insofar as that is possible. And I believe that this is an important moment that is granted to him, and granted not only to the civil parties, but also to Cambodia at large. And therefore, I think it would be a pity if he did not accept this opportunity. And I would like to let you know that we will provide our list of questions ahead of time. And, of course, we intend to put these questions within a reasonable amount of time, and we will not, of course, dwell on topics that are useless. So therefore, we're perfectly aware that it is out of the question to question the accused during an indefinite amount of time, which would be useless. So I hope that Mr. Khieu Samphan will be in a position to reconsider his decision. In any case, that is what we hope.
The President, thank you. We would like to hear from counsels for Mr. Khieu Samphan and Mr. Khieu Samphan himself, what they would like to respond to the observations made by counsels across the bench.
Well, we filed a notice explaining our position in a very clear way, so I don't believe that you expect me to repeat what I already filed in this 11-page submission. Well, when I listen to the prosecution and to the civil parties, I don't feel that we're in a trial anymore. I feel that we're now partaking in an international conference on the history of Cambodia, and I don't understand why Khieu Samphan would have the slightest inhibition about expressing himself. That is, of course, a circumstantial opinion. The truth of what's happening here is that we are in a trial, and we have made simple requests, and all of these requests have been rejected by the Chamber, And we believe that this violates the most elementary rights of our client, and therefore on this basis continuing to participate in these hearings does not mean anything for him right now. Mr. Kusampan took his decision on his own, and maybe he will share a few words about this with you, but as far as the detail is concerned, in our submission E288/4, everything is very clear.
The President. Thank you, Counsel. Mr. Kusampan, would you wish to respond to the observations made by the co-prosecutors and lead co-lawyer for the civil parties? Mr. Kusampan. Good morning, Mr. President and Your Honors. And good morning, everyone in and around the courtroom. I would like to inform you that I have reasons that I have decided to exercise my right to remain silent. The reasons are because the court has failed to respect my rights and the rights of my defense counsels. At the beginning, I had faith in this court, but after that, until the last moment, I have no faith in this court. That is all, Mr. President. Thank you. The President, thank you, Mr. Kusampan. It is now appropriate moment for adjournment. The Chamber will adjourn until 11 o'clock. The court is adjourned.
សូមអញ្ជើញក្រោកឈរ